Friends, much is said about me, but the topic that is given to me is so short that it is drafting in the trials. So, as it is, there are two facets of it. One, this has started a bit late. So I was requested that it has started a late. Please don't mind. Probably must have been a reason because there is no much subject as far as drafting is concerned on the criminal trials. Probably it came as a goon to me, as there is one thing very clear. There is nothing like drafting on the criminal side except to know the ingredients of an offense for which you intend to make an allegation of. The basic is Indian Penal Code. That's what it probably appears to be. Is otherwise, there are many things which have come now. Whenever you are intending to, I can put it this way, to give it the issue of trial is what the subject for the day is. You can basically, the drafting you can decide like this. One, the petitions, revisions and the applications like under 482 with the inherent powers. So that is one part of it. Complaints, revisions to the sessions and appeals is to the sessions, and High Court equally is the powers of revision and appeals are same. So therefore, bifurcating largely into three aspects of the whole thing about how to make a drafting the situation is. But now let us restrict only to the point of the trials as far as the criminal law. Mr. Kanitkar gave the examples. Ultimately in a criminal trial, the evidence, if you are on which side of the matter, if you are on a prosecution side, whether you are on a criminal side of the defense, but still the fact remains is you must know your Evidence Act well within the parameters so that you can either take advantage or give a disadvantage. If you are on the defense, you take advantage of the position and give a benefit to your clients. And if you are on the prosecution, then also you must know what is to be brought on record and what is not to be brought on record. So if what is to be brought on record, what is to be not brought on record is what is to be looked into. Now on the criminal side, first let us take a trial. How it happens is this. You lodge a complaint either with the police or with the concerned magistrate if it is not entertained. Why all the offenses are not entertained by the police is there is a bifurcation, therefore cognizable offense and a non-cognizable offense. Once if it is taken to be a cognizable offense, the offense where the police can take it and reduce themselves, they'll reduce your work 50%, they will do the investigation for you and file a charge sheet accordingly. So therefore there is no question of any such drafting comes in, but in the event if you have to give a complaint, to the concerned police about it, then it requires ultimately to think about it, that what is the allegations which you want to bring it to, what is the allegations that you want to hold it to, and whom you want to hold it for what offense. If that is what is broadly understood, then you can streamline to say that how you can put the facts covering certain aspects and not covering certain aspects within the framework of law, then use it for the benefit so that the complaint becomes acceptable even by the police. So this is one part of it. So therefore, to broadly first to come to a conclusion that the offense which you intend to allege against a particular person or against a group of people, you will have to see, which is there in the schedule, you don't have to break your head on that. But the fact remains is whether it is a cognizable or a non-cognizable. Once if it is made into an aspect of a cognizable, your worry is 50% reduced. Just you can file a complaint. It is not necessary that if they go to police that it will happen. So even if it doesn't happen, at least it will cover up to an extent to say that they don't say it is a civil side or they may say it is something else, but at least you have a right to come before a magistrate and put your grievance in the format of a complaint and give a complaint. There are two aspects of it. One, if you want an investigation to be done by the concerned authority, that is the police who are in this case, who have an authority to seize the documents, look into document, record the statements of the witnesses, and otherwise reach to a conclusion. If that is what you want, a simpliciter you have to write and say that if you are saying it in the format of not even writing anything, that this is an incident which has happened in front of my office, somebody A hit B, and this is what has happened, is lying on the road. That is sufficient enough, it can conclude. But the fact is, if you are working as a private complainant for filing a complaint, then you will have to disclose the offenses which have happened, which according to you have happened, and what an offense is. To tell the concerned person that what an offense is, then you will have to meet the requirement of an offense. If you're, for example, if you're giving an example to say, what should be a sambar? Sambar will have ingredients. Equally like that is the ingredients for the offense. If you want to say that it is an offense of cheating, you will have to compulsorily write to say that yes, it was a fraudulent representation, it was an intention to cheat, it was he who induced, therefore a wrongful loss or a wrongful gain. These 5 ingredients will have to somewhere come on the record. Unless and until these aspects are not covered, an offense of a particular nature is not made out. So therefore, while drafting a complaint, it is a must to know that this is a requirement of law and this is what you are putting it in writing. This is not when you are making an application that something can be taken from outside. It is you must put it in the format of a complaint so that when you are either going before a magistrate or you are going before the concerned person, that is the police, that they would take cognizance, either they would do the investigation, or if you have gone before a concerned magistrate, then he would send the matter to be investigated. But unless and until it meets the requirement of a basic 2 aspects, that is cognizable and non-cognizable. If it is offense of a non-cognizable nature, then you will have to seek a permission under 155(2). But the fact is that this is not going to be investigated by the police. So therefore, you have to just file a complaint, and a private complaint is filed before the concerned magistrate within the jurisdiction who is taking where the offense is committed. So what is that? There in that, even if it's a non-cognizable complaint, you will have to give the ingredients. You will have to say that these are the requirements. And those ingredients and requirements, unless and until put, it will not, even the magistrate may not issue process. What is the process? The magistrate, what you have said about in your complaint, that's going to be the base. Even if it is not accepted or accepted, at least the record would show that you are intending to put it on record that this is an offense committed by a particular person in the nature of so and so. You may not write the section, you may not give this, but the ingredients you will have to write. He is a man who made a representation to me. He is a man who came to me and said, you give me 10,000 rupees, I'll double it in 1 month and give you 20,000 rupees, and that is how I was induced. These issues will have to come. You can't simply sit and say that I've given a money to a man and he was to make it and then he didn't give and he is not there. Will only make you an extent to say that it is a civil law which will go to the civil side. So if you are bringing it within the framework of a criminal side, you will have to show the element of criminality. The criminality is the mens rea. So mens rea would come from each of the offense. So a man who has an intention to cheat, the man who has an intention to commit a fraud, the man who has an intention to create a document as a false nature, a man who had some other aspect by which he deceives you. He comes to you and makes a representation for deceiving. So unless and until this simple aspect is not taken into a complaint, even the magistrate will not be in a position to appreciate. So supposedly for any reason, in spite of this, if it doesn't happen, at least you have a remedy to go to the jurisdiction of the appeal. In appeal, you can mention it to say that this is the process ought to have been issued. So therefore, this recognition ought to have been done. This is the requirement which is given. These requirements are met with. It is shown in the complaint, but still also it is not appreciated. So therefore, when you are going to the appellate jurisdiction, showing your grievance that in spite of this, that it is not happening, there at least you will have a remedy. What is checked there is whether a legality, impropriety and incorrectness of the order. If it is not happening in your favor, at least there is something available. But if it is not there existing at the bottom itself, even if you go to the sessions, even if you go to High Court, the fact would ultimately remain is that it is not there as an ingredient, so therefore nobody will appreciate. The appreciation, even when you're going under 482, will not be available to you unless and until this part is not there in your complaint. So therefore, in a trial, it is a must that when you are filing a complaint of a nature, you take care to see ultimately that every ingredient in one or the other format is put up, is there as in your complaint. Now I'll give you one more example. In one of my cases, it was a case of some IAS officer who had filed a complaint in a society against 10 people of the society members. A meeting was held. In that meeting, everybody decided that he is trying to throw upon his power as an IAS and he is disturbing the fabric of the society was used. So therefore, he should be thrown out of the society was the meeting for which it was held. Unfortunately, he took it offended. He intended to file a complaint before the magistrate under defamation. Defamation complaint was filed. Process was issued. He said, this is what has happened. It was on the basis of an incident that the committee had called for a meeting, and there in the committee it was decided unanimously by the people or the members of the society saying that he is a man who is trying to throw his power on us and he is trying to spoil the fabric of the society and hence he should be thrown off. This is what was the basis. The complaint didn't show that this is what is being said by whom. All they said is they annexed a meeting. This all contained, the complaint contained only this portion. This is what is being said and accordingly it is being recorded. So the revision, the party failed. When in High Court, very recently when it came, twice it got adjourned. But ultimately the fact remains is, the court ultimately was asking the same question what I was intending to argue before the court, saying that this is what is the position of recording of what has happened in their meeting. But it is not saying that who has said what and who has been disturbed with this. That is not what a part of the record, and the requirement of section 419 of the Indian Penal Code is, that is defamation basically, is that the who is spoken, at whose interest it is spoken, the interest has to be necessarily to defame that man. But what is this? This is only a recording of what has happened in the meeting. This is the situation how a simple good case about he happened to be there in the meeting. It is said before him. But unfortunately, it is not recorded there, and what they have used is only that portion of the material to say that how a defamation is taken place is about. In the notes or the minutes of the society, they recorded so and so attended, and this is what is it is unanimously decided, and by merely unanimously deciding who is said, for whose benefit it is said, in what context it is said, and ultimately court came to a conclusion that this is not meeting the requirement of law to say that who has said it. If an imputation is not mentioned, if specifically what imputation is not mentioned, so therefore the requirement of an offense of defamation is not made out, is what ultimately court came to a finding and gave a benefit to him, saying that this is the position of law, that requirement is not done. So this is where we fall in. Ultimately it is this requirement of an ingredient which has to be a base to come to a conclusion in the event if any process is to be issued. So therefore, the process that is to be issued will have to be on the basis of these ingredients only. So the ingredients which will have to be put to each of the section for which you are intending to make an allegation is available and is known to you. So therefore you have to be only cautious and careful enough to an extent to say and give it to say that the requirement will give you the benefit if you are on the complainant side. So this is what is broader perspective of the complaint when you are filing it. But however, as far as the trial is concerned, equally it is so that it is, if you are on the defense side, it is not necessary to look into anything. It is not necessary to put anything in writing. You can just be quiet and be out of the matter, is all the defenses which each of the matter will take you to. So you don't have to be extra smart in that. You have to do is only take a situation as it is and see where you are, which is beneficial to you, where is beneficial to you. By keeping quiet, if it can be beneficial, you have to take advantage of that as a advantage to you. If talking something and bringing it on record is what is an advantage to you, then you put it in writing. So therefore, the drafting of a particular situation, even there are many applications you may have to make. You don't have to give anything much in that. So therefore, the requirement or the basic genius under which you go for to see that what is required. Supposedly, for an example, I have very simple application for exemption if it is to be given. An accused doesn't intend to come on a particular day. You file an application. Invariably, everybody does it. Invariably, everybody does it. Saying that, yes, he is unable to come. So this is the application which is taken on record. That's a part of the drafting. But it doesn't end there. The simplicity of it is, you will have to ultimately mention somewhere down the line, in the event if the witnesses come, you can proceed. We don't dispute the identity of an accused. So therefore, that is what is the requirement, is what you must see in any such application which is to come. So there are many aspects. These are all the practical issues which do derive. This practicality and the problems in the practicality and the solution to the practicality problems which have occurred can be, the situation only will teach you how it should be done and how it should not be done. But by and large, what is required under the law is that you put it to say that it is in a criminal trial, that you put it that these are the ingredients, this is where you mention it to say what offense is committed by them. The section need not be quoted, but the act is to be quoted, so which may fall into a particular aspect of it, and the complaint or the trial will proceed. Now let us take a situation where the revision or an appeal is to be filed against this. Appeal, there is nothing like a strict format as far as the criminal law is concerned. You have to be just careful about more logical than legal. So therefore, when you're talking about appeal or revisions against the same order of issuance of a process or some filing of a charge sheet, you are filing a discharge application. Yes, I'll complete that and come to this topic. So there are, once if investigation proceeds, and the investigation proceeds and they complete the investigation and file a charge sheet. If a man is in custody, within 60 days or 90 days, a charge sheet would be given to you. If a man is not in custody, is released on bail, then also on completion of the investigation, whatever the investigation that is being done is provided to you at a free of cost, is a requirement of law. Once that is given to you, ultimately it contains, what is the charge sheet? Charge sheet is containing of statements which are recorded by the investigating agency, the documents which are attached along with that. If it's a case of a cheating along with forgery and other connected aspects, then the documents will also show that how this document is forged or otherwise. If a document is annexed along with the charge sheet, is what is the one single compilation, that is what is given to you is, you will have to see the statements under which the role is given to you and the documents which are annexed to you, and the admissibility of evidence as far as that aspect is concerned, and reach to a conclusion that in the event if you have to make an application for discharge and be out at the initial stage itself. So what is a discharge application that you must draft for? The discharge application that you are drafting in the trial is that it is accepting everything as is what is being said by the investigating agency. You still put it to say that these offenses are not made out because it is not meeting with the requirement of an offense of as the ingredients as is required by law. Supposedly, if take the case of a cheating. If a cheating requires a fraudulent representation by which you are induced, and that is how there has been a wrongful loss or a wrongful case, and that was with an intention of cheat, or it is an intention is to deceit, then if these 5 ingredients, if are not showing, you will have to ultimately fairly put it to say that this is how the cheating is not taken place for this simple reason, and these ingredients are not met, and that is where you will have to take only to that extent a caution to say that it is not a case of a cheating, but it is a civil transaction for which brought under cheating. So to say that it is, though it may look simple, but it is quite complicated when a situation has to go through the aspect of statements which are recorded. So one, the requirement is that you accept everything as a charge sheet which has come, then still say that an offense is not made out. So therefore those documents and the statements which the prosecution itself is relying, on which you also are relying, are trying to say accept everything as it is and then give me a benefit of discharge, is what is the provision which is available in law. And therefore you can try to give this, you will have to make a conclusion. First, these whether statements, does it really give me to say that I was the one who represented fraudulently? No. So this ingredient is not available. So this is one of the compulsory requirements of law. This is not available. So then the deceit, was it a deceit? No. Then you say that how it is not a deceit. Then thirdly, is it a wrongful gain or a wrongful loss that has happened? No. Then say that how it is not a wrongful gain or a wrongful loss. Fifth, you will have to ultimately again say that it is by this virtue that it was not an intention to deceit. If you are saying all these 5 ingredients that you are not meeting with, any of this also is not met with, still you get an advantage and you can be out of the case as far as the case of a cheating is concerned. So now it is a case of a cheating. Equally take the situation of a criminal breach of trust. A trust under which the criminal breach of trust is where the violation by virtue of either oral or in writing an agreement, and any violation for which a thing is being done contrary to what is being written or being told and converted to one's own use. Conversions to one's own use is said to be a criminal breach of trust. So therefore criminal breach of trust, the moment it comes, then it is the criminal breach of trust by a public servant, agents and other, which is with a higher. This is exactly what has happened probably now in that Chanda Kocher's case. Initially the investigation agency, that is CBI, never came out to say that it is a criminal breach of trust by a public servant, which was punishable. So therefore the requirement of law in that Arnesh Kumar, that you must give a notice, popped up. Had it been mentioned to say that it is the punishment of 409, that is a punishment for a public servant in a criminal breach of trust. It is same criminal breach of trust but by a public servant. Then the punishment goes to a life imprisonment. So once, because it is a life imprisonment, and then the whatever pay notice which the Honorable Court, while deciding this and giving a benefit, is not mandatory, is need not to be given. So therefore there wouldn't have been any illegal detention by not giving a notice and detaining a person. The person couldn't have got probably there. But anyway, that's the facts of the matter. The fact of the matter as far as that is concerned is where the punishment of a criminal breach of trust now is 3 years, and it goes up to life in case if it is the same wording, if it's a public servant, agent or an agency or a transporting who is taking it as an agent or a principal or a banker. So therefore these qualifications are given. Within the framework of these qualifications, you can take advantage. Now the question is, as far as the criminal breach of trust, which we have taken, the trust is, this is exactly opposite of cheating. Cheating is where there is an inducement, and here in a criminal breach of trust, it is entrustment. So I on my own giving you is an entrustment or holding a dominion over the property. That is what is defined in law. Either a person holding a dominion over the property or is one is entrusted with the property is in violation of the direction. So therefore the third ingredient, violation, and fourth, in the direction of either oral or in writing. Fourth, and fifth is conversion to one's own use about a thing which is given is committing a criminal breach of trust. So now, while drafting a complaint of a criminal breach of trust, when you are going to say, you can't say that it was a fraudulent representation by which I was given. So you will have to say it was entrustment. The moment you say that I have entrusted to him this, then the question of cheating goes off and it remains mutually exclusive. Cheating is an entrust, the criminal breach of trust is an entrustment, and as far as the cheating is concerned, both are, though the commercial transactions of a nature similar, in commercial in nature, but one is against other, one is an entrustment or the dominion of the property, and other is where by virtue of your representation that a thing happening and with inducement taking place. So inducement is obviously, even otherwise you don't have to know the law, inducement is against the entrustment. So hence, when you're making a distinction while lodging a complaint, at least you will have to see this difference, that whether you're putting the ingredients of an offense of entrustment or you're putting the ingredients of an offense of cheating is what ultimately your facts will tell you. But the facts you will have to segregate in such a fashion that you give a definite offense to a particular act done, and therefore that either when you are a complainant, you can take advantage of filing a complaint. It's nothing like advantage, but at least you can pursue your complaint. You can reach to the pursuance of a complaint, but as far as otherwise these ingredients, if are not met with, you don't reach to that conclusion, and the appreciation may not be possible to give you a benefit to say that an offense is committed. Now, by drawing a distinction as far as these two aspects is concerned, supposing take a moment that there is a offense which is already made out. So charge sheet is either filed or you have filed a private complaint. So as far as private complaint is concerned, there is a discharge which is available. So again a situation of drafting would come in, and if it is a private complaint also, there is drafting which is available. Therefore you may have to move an application under 245 if it's a private complaint for a purpose of discharge only to be out of the matter. This is where in two aspects the drafting can come. So you will have to make out ultimately if it's a private complaint, unless and until there are other documents on which you intend to rely are coming on record, there is a provision in law where the evidence is led even in a private complaint. So evidence is led, and that particular time the framing of the charge takes place in the private complaints. So therefore, in private complaint, when the charge is to be framed, that time you can move an application. Again, whatever the requirement, keeping in mind that how this offense is not made out, you reach to that. Therefore, you cross-examine or don't cross-examine. It is not necessary that every witness who is stepping into the box, you must cross-examine. You may ultimately, it was just Srikanji Kanetkar was saying the same thing. So therefore you must know what is proved, what is not proved. If it is not happening within the framework of law of evidence that it has not come, you must take advantage and then accordingly say that under these circumstances the evidence on this issue has not come. So therefore that I may be discharged because an offense is not made without this. This is what it proceeds. Once if this discharge application or drafting situation, you will have to ultimately take it on the basis of facts of the each case and how that you fall into. Now if you don't succeed, the second situation comes of drafting is in appeal or in revision. Appeal would come in a criminal side from the trial where it is concluded either this way or this way. So therefore, if the prosecution has proved its case, then the appeal would come and you file an appeal, again the situation of a drafting would be there. So then you will discuss on the point of evidence. The evidence that could not have been looked into, evidence which is inadmissible in law, the evidence that is not proved are the aspects which are available to you, which you write it by basis of that. Or in the alternative, there is the section where provides that certain when you are getting an evidence, it is getting into more of evidence part rather than defense. When doing the cross-examination, that Mr. Shetty will be probably covering it, the aspect which you intend to take, the cross-examination of a particular witness, you do it with a definite idea that what you want to have it in cross-examination to nullify about the examination chief. Either by facts that by way of a rebuttal or by bringing this on record are the only two aspects in which you do it. So therefore, there is a statement supposedly is recorded by the police, contrary, and the witness coming to the witness box and saying that this is not has happened like this. So there is a procedure in law to get the contradiction or an omission on record by which it is that what he has said in the statement and that what he has read in the evidence by giving it in your cross-examination. So if there are two possibilities which are created, then you fall to that and then take advantage of the situation. There, supposedly these aspects are taken into an appreciation in appeal to say that this is what is being admitted by the witness, this is what is being said by the witness, this is what was there in the statement, how it is a contradiction, where the court could not have looked into is what then you will have to mention it in your appeal. Ultimately, you can put it within the framework of not necessarily by way of a particular wording, but you can take advantage of the situation only if you have brought it on record in a cross-examination about a particular concept of a contradiction. So now what is to be looked into, what is not to be looked into, what is proved in the evidence, what is not proved into the evidence, ought to have been proved into the evidence are the aspects will be a consideration in your appeal if you are convicted. The documents proved, not proved will also be a record. The Evidence Act provides for all these issues, including now electronic records which are created now. That's one of the topics today probably in the trials itself. Said whether what can be looked into, what is not looked into from the perspective of that. So even there you will have to study the situation to say that how this document has come on the record and is contrary to the law and ought to have been proved, ought not to have been proved, ought not to have been looked into is what you take into your appeal, and this is the second kind of a drafting. So as far as the same drafting in a revision application is concerned, you put it to say that ultimately whatever the order that is passed, either it is illegal or incompetent, the impropriety is about the facts of the matter. The facts, if are wrongly appreciated, impropriety will come in picture and the illegality will come in picture. So therefore, these are the three aspects for which a revision would lie. Appeal is a matter of right in the event if you are convicted. If it's a appeal against acquittal, then you will have to probably go to High Court on that. And the sessions also if it's a police complaint. But the fact ultimately is this only. Drafting would come to say necessarily that you will have to pinpoint from the law that how these facts do not fall into category and do not take it to a conclusion, and hence that they can be appreciated either for the benefit. Another 5 minutes, I'm finishing it. Now comes the other aspect of which I was just requesting to, is about going to the High Court under 482 separately on a situation. The 482 is a different aspect, the inherent powers which are available. The process issued on a complaint, if it is not appreciated by the consent court, by supervisory powers or under inherent powers, you go to the Honorable High Court and say that how this is not done, how it ought to have been done. So therefore, this topic may by itself be a situation, but in 482, it is going to be more on law than on facts, whereas appeal and revision can be more on both facts and law, and the complaint is totally on facts. And this is what is the distinction one must keep in mind before you go either to the magistrates or in appeal, revision or under 482. This is what I think probably concretize the whole situation about the drafting is what I have understood to make it simplify and put it to you. And thank you very much.